What did you want to say?
On no, August, look in here.
All right, I'm going to call the case. It's entitled Crown Asset Management as an assignee of First Bank and Trust versus Catherine Irwin. The file number is 2512-GC. It's a claim for $2,287.43. Ms. Irwin.
Yes, sir.
Sued by this company. And from the very beginning, she contended that this was a fraudulent debt incurred by her short-time husband, John Hardy. Here's Attorney LaCorey. She's a little late.
Sorry.
You don't need to apologize.
Hello, good morning.
Good morning. I started the case. I'll back up and start over again. We're making a record of the matter of Crown Asset Management versus Catherine Irwin. Attorney Veronica LaQuarrie is here, and she was here the last time on August 11th, 2025. Catherine Irwin is here with me today. She's in the conference room at the courthouse. The claim is with costs $2,287.43. Ms. Irwin had contended all along that this was a fraudulent card. And way back in 23, the Discover Bank said, we're going to look into this and see if it's a false debt. The plaintiff has supplied the charging history of this, and there were a number of charges here and there, including a number of charges in Three Rivers, Wild Bill's Tobacco, gas stations locally, Blue Gate Theater in Shipshewana, some other things that were charged on the card. Ms. LaQuarrie, could you turn your camera on?
Yes, I apologize. I didn't realize it wasn't on.
All right. Well, we started at 8. You came in a little later, so we had to back up and start over again. Anyway, when we were here in August, you did not ask for a default at that time. Ms. Irwin did not appear, but you said there was a fraud investigation going on and we would reset the matter about 60 days and see what the status was. In the meantime, on October 8th, I received a proposed default judgment from the plaintiff. I haven't signed it. Ms. Irwin is now here. Ms. Irwin, is it still your contention that this was a fraudulent use of your name and information from John Hardy?
Yes.
All right. Well, what if you and John Hardy entered into this marriage and entered into this credit card, and both of them were a bad idea, and charges were made while you were married to him, and gas stations, tobacco shops, concerts, then you divorced him and you got stuck with his bill as a co-signer on this credit card. What's your response to that?
This man is a fraudulent person. I entered in a marriage for saying that he had money and all this. It is unbelievable. He took me across country. I had no indication that when he was doing this, that he was going to be a fraud. He scammed me into marriage. He scammed me out of my money. He scammed me out of my down payment of my house. This is just a tidbit of what went on. He apprehended me practically, wouldn't let me talk to my friends, wouldn't let me do anything, took me across the country, took my keys, took my ID. I was like a hostage.
All right, well, let me stop you for a
It's
minute.
horrible.
We adjourned this for 60 days and you and your plaintiff client were going to look into this. What have you discerned regarding this?
Yes, Your Honor, my client did look at it, and after reviewing all of the paperwork, they said that it didn't really make sense. At the end of the day, they did see that, the credit card was opened by the parties, payments, there were some payments made, and then the payments stopped. So they do not agree with the fraud. And then that's why they wanted to proceed with that default, especially because she didn't appear at the last hearing. Now, of course, I'm willing to, talk about a settlement with her, but we can't. The client cannot close it out. They do not agree with the fraud claim.
Your Honor?
Yes, just a moment.
Okay.
You were subject to default last time because you didn't show up. They didn't ask for a default. They continued it for today to see if you'd show up. So they can't now ask for a default. They had an opportunity to do it and didn't. You're here now. Their contention is whether this was an ill-advised enterprise on your part, marrying this guy, signing your name on a credit card, going to Kentucky and doing whatever else happened, that it isn't their fault. Somebody charged up $2,000 worth of stuff and never paid the bill, and they still want their money. So I'm not gonna grant a default. We may have to have further things, including a trial, I suppose, if necessary, or motion for summary disposition. I'll explain that in a minute. But the bottom line is, apparently you signed this credit card while you were married to this guy. Do you smoke?
No, never.
So everything at Wild Bill's Tobacco was for him?
Yep.
All right. Well, let me put you in what's called a breakout room. What did you want to say?
On August 11th, I was preparing for surgery, which I have now had on August 29th.
All right. Well, I'm not going to grant the default.
I have not worked since 1/6 of this year.
Now, you used to work for the Transportation Authority. Were you still there?
No, I got hurt on the job and my whole left side was destroyed saving someone.
All right. I'm going to put you in a breakout room. I'm not sure we're going to accomplish much, but I'm going to let you speak privately with Attorney LaQuarrie, which is why you're in that little conference room, so you can speak privately outside of my presence.
Yes.
If we were both here in the courthouse, we could just do it in one of the conference rooms, but we use this electronic breakout room for you guys to talk privately. So I'm going to let you two speak, and then I'll wait here and think about things. And I'll see you in a few minutes, and then we'll decide how we're going to proceed. Click the button that says join. Do you see it come up on the screen there? Do you see the mouse?
Yeah, I'm not, I got one arm. Hold on. Try. She's doing it for me.
Yes, see if you can click that.
Did I do it?
Not yet.
Sorry, Your Honor, I'm not,
All right, you're all right. Elaine, can you help her?
I'm trying. It's not doing anything. I'm sorry, Judge.
All right, we'll get somebody to give you a hand. Elaine, could you help her, please?
I know here she comes. I tried to click it, but.
Okay. Got it.
All right, we'll move on to our next case while they're talking. Good morning.
Good morning, Your Honor.
Good morning, Your Honor.
I just put a couple people in the breakout room in an earlier case. Let's set our premises here. Good morning to you both. It's early, 9:15 on a Monday morning. Thank you for being here by Zoom. This is file number 251186GC. It's entitled LVNV Funding versus Dennis Little. The amount at issue is $1,824.07. The Stillman Law Office is here on behalf of the plaintiff by attorney Maxwell Quinn and Jennifer Payon, as the French say, is here on behalf of the defendant. Ms. Payon's firm also often represents credit defendants. I'm assuming the two of you have talked. What's the status here, Mr. Quinn?
We have not talked, but we do work together frequently. And what we normally do is just ask for a standard pretrial scheduling order with 60 days discovery, and we do resolve most of our cases. So I'm pretty sure we will this time as well, Your Honor.
Well, the amount at issue is not huge, $1,824. Ms. Payon, you concur with that?
I do. Thank you, Your Honor.
Ms. Payon, are you representing this defendant in other debts as well?
My firm may be, but this is the only file that I personally have.
All right. Well, I'm granting discovery and we'll adjourn this for 60 days. Which is hard to say this, but that would adjourn this to December 15th.
And I do want to let the court know that I will be having a baby at some point in December. So you will likely not see me for a few months post mid-December. So
All right, well, is that, do you want me to set it earlier than that?
that actually should be perfect timing. And then hopefully we can get this one wrapped up. If not, I will have either.
Let's move it up a week. Okay, baby has different ideas. December 8th at 9 a.m. for continued pretrial.
All right.
All right, I'd put you in a breakout room right now if you're interested. Otherwise, you can just talk at your convenience. I know that you do work with a lot of different collection firms and they work with you often. If you wish to talk now, I can try to facilitate that, or we'll just continue this December 8th at 9 o'clock.
I think we're fine unless Maxwell feels differently. We'll communicate via email and get some stuff going back and forth.
All right, very good. Mr. Quinn, anything else for us?
Nothing else, Your Honor. Thank you.
All right, good morning. Thank you.
Thank
Isn't
you.
Zoom
Take care.
wonderful? We just did all of our business in 4 minutes. Neither one of you had to drive to Centerville, but one day you'll get to come to Centerville and then you'll see what you've been missing. All right, thanks.
All right. Take care.
All right, take care.
We're all set, Your Honor.
All right, let me bring her back in. It's gonna take 30 seconds.
No worries.
I took care of another matter briefly while we were waiting.
That's great.
Yeah, it is. We set these 15 minutes apart and we were doing a half an hour, but 15 minutes seems to be sufficient for these short pre-trials. All right, Miss Irwin is back. Had an opportunity to talk to Miss LaFari. I spelled your name with a Q, so I'm sorry. Your camera's off again.
My name is spelled with a Q at the end.
Oh, yeah, I got the Q in the wrong place.
Oh, that's okay.
And I've been saying it wrong too, so I apologize, but
That's
the
okay.
parties were placed in a breakout room, and did we accomplish anything?
So, unfortunately not. She's not able to accept the settlement that I have authority for. So I'm gonna try to plug in a hardship request for her because it sounds like she only has SSI income and doesn't have any assets. But if that's not approved, then we may have to, proceed with the motion. Because, if a judgment is filed against her, I told her that, it sounds like she's not collectible anyway, but we would have to proceed. So that's kind of that's kind of the update.
All right, Miss Irwin, let's assume everything that you said is true, and I'm not assuming that it isn't. That this guy was a fraudster, he was a bad person that ruined your life. You signed this credit card and got into this bad deal, which spilled over onto this company. Apparently Discover Bank did some sort of fraud investigation in 2023, but that didn't go anywhere. And this company also is not willing to grant fraud relief. So, but at some point they're gonna have to prove this. So what they're proposing to do is to file what's called a motion for summary disposition.
Okay.
I'll explain that here in a
Discover
minute.
wiped everything off.
Say that again.
Discover wiped everything off.
Do you have some documentation to that effect? I have your letter that they wrote. I think the plaintiff sent me that, not you.
No, I sent it to you. And
all
I
this
also
charging-
have a copy of
Yeah, you did
Party
send it.
Social Security in that packet that shows that he made no earnings for the last 20 years. I think there's like $10,000. So he's truly a fraud. And he's
Well,
also.
all right, I accept all that. The question is whether you got defrauded and signed this. Now, the Discover letter that you gave me from June 28th does not close it. Based on our recent conversation about your unrecognized activity, we've opened a fraud dispute to review your case. No further action is required of you as it relates to the review at this time. We will contact you if we need any further information in the course of the review. But I never saw something later that said, hey, we determined this is a fraud and you're not responsible for it. Do you have something like that?
It says, if you look at the information that I gave you, you look at it, says negative, 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 negative. They wiped it all off.
Yeah, what they did is they wrote it off and then they sold it to a debt collection company.
No, I
Um,
never paid a penny. They told me I didn't have to. I'll get a letter
right.
of that back. I also went to the police.
I saw that. Uh,
And also
all
tried
right,
to sue him.
those are all part of your defense. The problem is, we're not in small claims court. We are in general civil court.
Okay,
And you've got these letters from Discovery, but you don't have any person from Discovery that can verify the letters. And I don't see what you see where they just said, we've excused this claim. These bills
I
went
can
to,
call.
they went to your address on West Michigan Avenue.
Mhm.
Charges were made, payments were made, more charges were made, more payments were made, and then you stop paying on the charges. And so they're saying, hey, she the card is in the name of Catherine Irwin. Someone used the card, sent the bill to Catherine Irwin's address. Someone paid the bill, made additional charges, paid the bill, made additional charges. So their contention is we sent you a bill, you paid it, and acknowledged the use of the card. At any rate, I certainly think there's much merit to your argument, but neither Discover Card or this law firm is accepting it. So,
Discover did, I can give you a document. I'll call Discover today, because they wiped it all off and they said, yes, it was fraud. And I
all right,
didn't
well,
have to pay anything.
if you have a document to that effect, I think the plaintiff might like to see it.
I'll give it to them.
All right, I'm gonna grant 21 days to file a motion for summary disposition.
Okay,
21 days to respond and continue this for further pretrial and hearing on motion. For December 15th, 2025 at 9 o'clock.
okay.
Ms. Irwin, if you can find that letter from the Discover that says we determine this is a fraud and we're excusing this debt, they'd like to see it. I'd like to see it too. If you have it, I think they just wrote it off
No,
and then sold it, but we'll see.
no.
At any rate, they
There's
still
another-
have to prove this, so they're gonna
there's
file a
another
motion for
fraud
summary
case
disposition.
that just was closed in Ohio, that he is on probation because he swindled out 2 other people and he.
Well, I don't disbelieve any of this, but he swindled you and you put your name on this credit card and the
Oh,
credit
yeah.
card was used and you made payments on it or somebody did. So
I
I'm not the
made
person
payments
bringing the
because
claim.
I'm trying to rectify the damage that was done for me. I cannot make any more payments. My life is
It's-
totally.
And that's the other issue. Even if they get a judgment, they're probably not gonna be able to collect anything.
No,
But I'm not the one that brought the case and I'm not the one that declines to dismiss it. So maybe we ought to just bring everybody here and have a trial. But let's try this first. They're gonna file a
Okay.
motion for summary disposition. I'm not
And
sure
we're-
they have enough.
and where do I give this to? Do you want me to just drop it off at the courthouse when I get
Yes,
the letter?
we'll try that. If you have such a document, bring it here and we'll forward it to the plaintiff.
Okay. All right.
All right.
Thank
Thank
you,
you.
sir.
Ms. LaQuarrie, anything else to address?
No, nope. Everything's good.
All right, I don't know if it's good, but we got it as far down the line as we can this morning. So, Ms. Irwin, thank you for being here. You need to make sure you be here at every hearing or you will get defaulted. But we'll try this again on December 15th at 9 o'clock. We'll give you a new notice.
Yeah, Your Honor, on August 11th, I apologize, but I was setting up for surgery for what you look at now.
Okay, all right, I'll see you in December. Thank you.
Sounds good.
Thank you.